Hello and welcome to the Herrington Carmichael Employment Law Update for January 2019. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and I'm bringing you the latest updates for the last month in the world of employment law. So, where do we start? We start with the big announcement of the government's Good Work Plan. This came out in December and provides a series of proposed regulations to come into effect in April 2020. Now, we'll be watching these regulations quite carefully as they develop and go through the relevant stages in the parliamentary processes. However, what the government is doing is the government is trying to implement changes to employment law to improve the world for employees and workers. However, although it's got a lovely spin to it, is it really delivering what employment law needs? That's another debate for another time. But anyway, where do we start with the Good Work Plan? Good Work Plan is talking about changing the rules in relation to employment particulars. So, in effect, an employee would have to have a written statement of particulars of employment from the commencement of their employment rather than within 1 month, and it would have to include other details than it wouldn't do ordinarily. So, for example, more information on the probation period, more information on sick leave, and more information about how long the job is likely to last. Added to that, the Good Work Plan is talking about making workers qualify for a written statement of particulars as well from the commencement of their assignment. What this means is that workers will have to have similar detail which you would give to employees. Added to that is the potential additional compensation available for aggravated employment breaches. Currently this is set at £5,000 in an employment tribunal, but it's talking about increasing it to £20,000. Next, in terms of the Good Work Plan, is changes to agency workers regulations. The agency workers regulations are perceived as being not strong enough, and that in fact workers are still treated badly compared to permanent employees. So the rules here are looking to be reviewed and updated so there are greater rights for agency workers to get the same benefits as employees within a qualifying period. Finally, let's finish with a case, because I know we all like the case authorities. This month we saw the case of Williams and Swansea University. This case related to unfavourable treatment in a disability discrimination scenario. In this case, Mr. Williams was disabled and he reduced his working hours as a consequence. When he came to retire, he received a lower pension. He argued that was unfavourable treatment. However, when it got all the way up to the Supreme Court said no, really that's not unfavourable treatment because it was a positive decision of his to reduce his working hours and therefore the pension reduced accordingly. Now, that's it from me this month. All that's left for me to do is to wish you a very happy new year and may it be really prosperous for you. You know where we are if you need us and we're always happy to help. I look forward to talking to you next month. Thank you.